Ladies and gentlemen, good morning. My name's Daniel Barnett from Outer Temple Chambers. This is the last day of webinars. We've been doing it for 3 weeks now. Many of you have been with us for every single one of the webinars. They're advertised as 28, but including the 3 bonus ones we've done, myself, Simon Chaplin, and Adam Solomon, we've actually had 31 webinars. This is number 30 of 31, and I'm joined today by Mo Sethi of Littleton Chambers, who is talking on restrictive covenants. Mo Sethi QC is Head of Employment at Littleton Chambers. He's also Vice Chair of the Employment Law Bar Association, and he recently appeared in the first ever restrictive covenant and confidentiality injunction heard before the Dubai International Financial Centre course. He's also appearing in the first ever leapfrog appeal from the Employment Appeal Tribunal directly to the Supreme Court. Hopefully he's going to tell us a little more about that during his talk, or if he doesn't, please do ask it as one of your questions. Mo Sethi, good morning.
Thank you, Daniel. Good morning, everybody. So what are restrictive covenants in the employment context? As is well known, post-termination restrictive covenants, or PTRs as I'll call them, are designed to protect the employer or their group companies against competitive activities by former employees for a certain period of time after they leave. Now, there are broadly 6 main types of restrictive covenants. First, we have the nuclear option. We have the non-compete covenant. We all know that that's aimed at preventing a departing employee from engaging in defined competitive activities in order to protect confidential information or strong client relationships. Secondly, we have non-solicitation covenants, which seek to stop former employees from seeking business from defined clients or customers, prospects with whom the employee had contact for a specified period of time. Related to that are non-dealing covenants, which are wider than non-solicitation covenants in that they prohibit a former employee from having any dealings with clients, customers or prospects. Fourthly, non-staff poaching restrictions. They prevent a former employee from enticing away, employing or engaging specific categories of staff over whom the employee has some influence. Fifthly, non-team move restrictions are becoming increasingly fashionable in my experience in this world. They seek to prevent a former employee from leaving to join a group of employees who have already left for a competitor. Now, they're sometimes referred to as waiting room or departure lounge clauses, whereby the employee must wait a certain period of time before they can be permitted to leave to join the competing business. And lastly, the 6th main type we all come across are non-interference covenants, which aim to prevent a former employee from seeking to divert supplier relationships away from the old employer. What I wanted to do after having to set out those 6 main types of covenants is to ask, well, what is the court's approach to covenants? What's the modern approach these days? Well, when considering whether to enforce a particular PTR, the court will consider a number of issues. Now, the starting point in the court's approach to PTRs is always, and must always be, that they are prima facie void and unenforceable because on public policy grounds they prevent open competition, so they need to be justified. The court then must decide what the covenant means, and it does so by applying the usual principles of contractual construction. And as was clarified last year by the Supreme Court in Tillman and Egon Zehnder, the court will also apply the so-called validity principle, meaning that if a covenant is capable of 2 alternative meanings, one which will result in invalidity, and then it will prefer the alternative construction if that is realistic. Next, a PTR must be aimed at protecting a legitimate commercial interest of the employer. Now, typically, these include protecting confidential information and trade secrets, client connections, supplier relationships, and maintaining a stable and trained workforce. In most cases, one or more of these legitimate business interests is more than easily established in my experience. The court then considers the very major issue of reasonableness. Now, for a PTR to be reasonable, the employer must show that it goes no further than is reasonably necessary to protect the relevant legitimate business interests that we will have just identified in the previous step. It's important to remember that reasonableness is judged at the time that the PTR was agreed. We know that from Pat Systems Holdings and Neely. And what is reasonable will depend on the particular business or business unit, the legitimate interest at stake that's sought to be protected, the employee's position, and of course the type of PTR that's sought to be enforced. It's often asked as to what is a reasonable period of restriction post-termination. And what will be a reasonable restriction period for each type of covenant will of course vary in each case. But it's not unusual in my experience for, I think it is unusual in my experience for more than 12 months to be upheld as reasonable in the employment context at least. On the issue of blue penciling or severing unreasonably wide or offensive parts of a covenant, the Supreme Court in Tillman last year clarified that if parts of a covenant are too wide, the court may be able to sever any unreasonable part if three conditions are satisfied. First, that the unreasonable part can be deleted without needing to add extra words. Second, the remaining terms continue to be supported by consideration. And thirdly, and importantly, the removal of the unenforceable provision would not affect a major change in the overall effect of the PTR in the employment context. In some cases, the court will then need to also consider whether the employer has repudiated the contract. Now that's because a repudiatory breach by the employer, which is accepted by the employee, will have the effect of releasing the employee from their PTR obligations. And we know that from the age-old case, century-old case of General Bill Posting and Atkinson. The next big question is to ask what evidence is there of breach by the departing employee? Is there a serious issue, in other words, that the employee has or will breach the contract? And lastly, but by no means least, the court always has its residual discretion on any application for interim relief because, of course, it is an exceptional remedy. Even if the PTR, when agreed, is valid, and even if it is found to be potentially enforceable, the court retains the discretion whether to grant the injunction application to enforce the covenant, be it at the interim application stage or be it at trial. Now, this will depend on the reasonableness of an injunction at the time the application is made, of course, or considered, including whether the employer, for example, has delayed. That's a classic reason for exercising discretion against the award of an injunction, or whether the employer has come to court with unclean hands, or whether damages would be an adequate remedy. Now, the test at court on an application for interim relief is, more often than not, the standard approach set out in the American Cyanamid and Ethicon case. We ask, as we all know, is there a serious issue to be tried as to the former employer's entitlement to a final injunction at trial? So that's the assessment being made. But the serious issue hurdle is an extremely low hurdle indeed, it must be said. So we don't often worry or spend too much time worrying about that question. Will damages be an inadequate remedy for the former employer, the claimant in the case? This is often the situation where that former employer's loss is said to be unquantifiable or uncompensatable, or the employee is short of money and would be unable to pay any damages at trial. The court might then move on to consider whether damages would be an inadequate remedy for the defendant, for the departing employee. However, there the court will often bear in mind the employer's cross-undertaking in damages, because that will subsequently compensate the employee for a wrongly granted injunction at the interim stage. The next stage that the court looks at is to ask, does the balance of convenience or the balance of the risk of doing an injustice lie in favour of granting the injunction or against? And in my experience, the court will often err in the assessment of the overall balance of convenience, if it can, that is, on the side of preserving the status quo. In other words, trying to do what it can to just hold the ring, to freeze the parties in their status quo position. And there's often many arguments as to what is meant by the status quo. Is it status quo prior to the employee's breach, or is it status quo immediately prior to the application? But nevertheless, that the judge tries to just freeze the current state of affairs pending an expedited or speedy trial, which can be had in a matter of weeks, if not months. And the court is also entitled on the application to take into account any clear view it might reach on the evidence as to the merits of the case. Now, that's a classic American Cyanamid approach, but the court may depart from that Cyanamid approach where there's only a limited time left to run on the restrictive covenant. And we know from cases like Lansing, Linden, Carr, and the Force and Sakama case in the Court of Appeal last year, that where there is limited time to run, the court will apply that more detailed approach. Lastly, I just wanted to say something about current trends as I see them. In terms of geographical scope, I think that increasingly in a global economy, geographical restrictions nowadays are only really suitable for certain types of localized or regionalized businesses. Think hairdressers. Another area where there's been developments is in relation to small or minor shareholdings. It's a fairly standard for non-compete restrictions to include a carve-out that allows former employees to hold small shareholdings in a competitor. But as the Supreme Court decision in Tillman shows, employers should ensure that the drafting of a non-compete restriction doesn't operate to completely prevent small shareholdings for investment purposes. Now, in that case, there was no carve-out in the non-compete for small shareholdings, so it was held to be unreasonably wide. We're also seeing increasingly garden leave offset clauses becoming increasingly common. And also, as I said earlier, increasingly seeing team move covenants inserted into senior executive contracts. That's really what I wanted to say in relation to current trends and developments. How are we doing for time, Daniel?
You're just about at the end of it, Mo.
Excellent. Should we move on to all the tricky questions that everyone's got lined up for me?
Fantastic. So we're asking questions to Mo Sethi from Littleton Chambers on restrictive covenants, and we've got lots of questions, which is fantastic. The first question is from Paul Marsh. Paul, you've already touched on this, but maybe a little more detail for Paul. What would be a typical enforceable geographic radius to use when drafting a non-compete clause? And is it different if in a big city such as London?
Well, it's absolutely important if you're going to go down the road of drafting a geographical restriction to justify it. As I said a moment ago, and I said it very briefly, I know, but if you're a business whose commerce and revenue depends upon the local economy, local footfall, for example, if you're a high street business, you're a local solicitor, you're hairdressers, something of that kind, then clearly you will be able to justify the imposition of a geographical restriction. How much of a geographical restriction, which is the really clever question, which has just been asked, and the tricky part, is always going to be difficult, and it's always going to be fact specific. So you're going to have some correlation with your customer base, some correlation with where you're attracting the revenue from, and then that has to be spread out, and then some understanding of what competition already exists within that geographical radius. So it's not me trying to squirm out of it by saying it's fact specific, but you're perfectly entitled to it. But certainly if you're a business without borders, if I can put it like that, then you will be hard pressed to be able to justify any geographical restriction.
Does the Office Angels case help on the issue of whether big cities have different rules or different approaches to geographical restrictive covenants? Office Angels, as you remember, was a recruitment agency where there was a restrictive covenant that said you can't become a recruitment consultant for a mile within central London or a mile around London, and that was held to be too wide in a dense city such as London.
It's partly because of the density of the geographical location. So, for example, if you're in a regional outfit or a small village, that'll be far more easy to justify. It's far more difficult to justify geographical restrictions in London, the Greater London area, or the City of London area in particular.
Question from Nigel Target. Nigel talks about social media contacts such as LinkedIn and Facebook and says they're becoming increasingly valuable assets for both employer and employee. If there are post-termination restrictive covenants in respect of such social media contacts, for example, requiring the employee to delete them from their profile, is there any way the employee can reasonably retain them within their profile?
Right. So the vexed question these days is who owns the asset? Who owns the LinkedIn account, the Twitter account, or whatever other form of cloud social media platform it might be? If the employer owns it, it's the employer's asset. It is protectable as a proprietary asset. You can obtain delivery up of it. You can obtain all kinds of interim relief in relation to it. If the asset itself contains, furthermore, not just being the property asset of the employer, but contains confidential information or trade secrets, all the more protectable. So yes, insert express clauses at the commencement of employment into employee contracts, making it quite clear who owns the cloud-based platform and the account in question. The problem is if they set it up in their own name, there's a conflict often with LinkedIn's own standard terms and conditions, but your focus must be on the contractual obligation that you have with the employee rather than the employee has with, say, LinkedIn or Twitter.
Interesting question from Sonia Patel. Sonia asks, what's your view, Mo Sethi, where an employee is promoted but doesn't sign a new contract and the employer tries to rely on the new covenants in the unsigned contract flowing from the promotion? Would those covenants be enforceable?
No.
Question from Henry. What practical steps should an employer take when they first discover competitive activity after employment has ended to be in the best possible position to obtain injunctive relief and damages? So I think, Mo, this is your top 3 tips on getting an injunction.
Right. Well, there's a lot I can talk about on this topic because, of course, it's what I always have to be advising upon. Pre-application considerations. Essentially, when the employee is breached or threatens to breach, you need to obtain relevant information or evidence. Firstly, you've got to make key decisions. Secondly, you've got to decide on a clear litigation strategy based on the key decisions. And you need to be gathering the relevant background information. Is the employee still employed by the employer? What are the circumstances of departure? What post-termination restraints are there? What's the client's perception of what the employee can do after leaving? What's the notice period? Is the employee paid variable remuneration that can be stopped? What approach has your client taken in similar departures? Can the employee be put on garden leave? Speak to other clients and other employees about what evidence they might be able to give you about the employee's misconduct. And then very, very quickly search for relevant documents. Have a really good IT monitoring system in place. Have COBRA-style committees set up if you can, as I have with some of my regular clients who are victims or involved in team poaching exercises. You need to have the ability to interrogate all the various IT systems, email accounts, cloud-based accounts, and things of that kind. You've got to have a good policy in place, because what you don't want to do is to be so aggressive in your interrogation of the employee's IT systems that the employee might accuse you of being in breach of the implied term of trust and confidence by being heavy-handed and therefore repudiating the contract and under general bill posting, making the PTRs fall away. So you've got to be proportionate, but you've got to be rigorous, and it's best to have that system in place beforehand.
Thank you, Mo. Patrick, I think your question's been asked and answered by somebody else. Mike Klein, how would you describe in simple terms to a small employer how best to approach setting post-termination covenants? I'm thinking about encouraging them not spreading a net too wide or for too long.
Absolutely right. It's the minimum necessary. That's your yardstick. The phrase no wider than reasonably necessary is the touchstone. So you've got to ask yourself a number of issues. What legitimate interest is this particular clause that you're beginning to draft aiming to protect? Because everything has to be catered and customized to that. It has to be, the more bespoke, the more enforceable. There has to be a linkage, a correspondence between the business of the employer carried on by that particular employee, the business activities carried on by that employee, and the business activities that are captured by the covenant. You've got to have it relevant to the employee's role. Think about what access that particular level of employee has to confidential information, what contact and influence that employee has over customers and over key employees. Think about the limitations in terms of the backstop period. In fact, do you need to really protect all customer contact that employee had with, say, customers in the last 5 years or 3 years, or is 1 or 2 years enough? If it's more than enough to go for what the previous 12-month period, stop there. Don't overreach. Then think about duration, think about geographical scope, think about the connection, as I say, with the protectable interest. If you've got an express garden leave, if you haven't got an express garden leave clause, make sure you've got an express garden leave clause in the contract. And then the question that you're always having to ask once you've drafted it is to stand back from it and say, well, is someone going to look at this and say, that a less severe restriction would suffice to protect the legitimate commercial interest that I identified at stage 1.
Penny Douglas, morning Penny, asks, is it better to give a specific postcode area rather than a generic 5-mile radius?
Yes.
And I've sometimes seen restrictive covenants, Mo Sethi, where the post-termination restrictive covenant says that you're not allowed to deal with or solicit work from the clients named in Schedule A. Schedule A is a list of 6 or 7 top clients, and then that list in Schedule A is updated and reviewed every year or so. Is that a good way of going about things?
Where would that Schedule A be? The Schedule A to the...
To the employment contract.
To the employment contract, I see. Right, so it's updated as you go along. There may be an argument in relation to whether that variation. So, for example, if you're trying to add far more a bigger if you're changing the category of clients that you're adding there, not just adding names which have fallen into the original category, but you're expanding the category of clients, then the issue arises as to whether the employer has paid adequate consideration for that variation, and if it hasn't, then that variation, because it's a contractual variation, may not be valid or enforceable.
Question from Gillian Howard. Gillian asks, if the employer breaches the contract, for example, by making a payment in lieu of notice when there's no pay in lieu of notice clause, or placing the employee on garden leave when there's no express garden leave clause in the contract, will the courts allow the wrongdoer to the contract, which will be the employer, to go on and enforce a post-termination restrictive covenant?
If the employer is in fundamental breach of contract in relation to the way in which it's put someone on notice, or the example that's just been given by Gillian, and the employee communicates acceptance of that repudiatory breach, then it would seem to me that the remaining post-termination restrictions arguably fall away, and it would be very difficult for the employer to try to enforce in those circumstances, if I've understood that question correctly.
And Gillian asks about an employer who puts an employee on garden leave when there's no express garden leave clause in the contract. Does there need to be an express garden leave clause, or can it be implied?
There is actually some interesting debate about this very topic, and I think that the reality is it's going to be very difficult to obtain a garden leave injunction. And for those, I haven't mentioned that yet, but the garden leave injunction is essentially where you're trying to keep someone to their notice period, keep them on your books, as it were, and keep them under your control, and not move to the competitor. And if you haven't got an express garden leave clause, it's going to be very difficult to obtain a garden leave injunction.
We're joined this morning by Mo Sethi from Littleton Chambers, who's answering questions on restrictive covenants, and Mo's with us for another 20 minutes. Mo, the next question is from John Hulson, who asks, how would a court treat a non-staff poaching clause, which refers to all employees, in a company which is small enough for the employee to know who all the other employees are, even though many of them are junior and aren't going to pose any real damage to the employer if they're poached?
Well, you've answered the question in the question itself. If there is no risk to any protectable workforce stability or training or a stable workforce issue, then any employee is usually far too wide. What needs to be done in those cases? And it's an interesting question because it's a small employer, and that's the conundrum here. So in the case of a small employer, I'd say it's arguable, and I think it's a very tantalizing question, because if someone poaches everybody, the business dies. But in most cases where there is a staff non-poaching restrictive covenant, which simply says thou shalt not poach or entice away our employees, is far too wide, because the employer has no legitimate interest, for example, in protecting receptionists, cleaners, postroom boys and people, things like that, because they may only have a protectable interest in people who are customer facing, in possession of confidential information, or in positions of senior influence.
Question from Julie Davis. It's a twist on general bill posting. If an employee resigns in breach of contract, so the employee resigns without notice, and the employer doesn't challenge this, could this jeopardize the employer's ability to enforce post-termination restrictive covenants on the basis that the employer accepted the employee's breach?
No, I think to the contrary, it vastly improves the employer's prospects on an interim injunction application to enforce the covenants which remain valid.
Why is that, Mo Sethi?
Because the employee is in breach, not the employer.
Chris asks, is a forfeiture provision in a long-term incentive plan, which is triggered by an employee going to work for a competitor, treated in the same way as a non-compete clause? So in other words, are forfeiture clauses in long-term incentive plans subject to reasonableness requirements if the employer wants to invoke them?
The direction in which the courts have been going on that issue, and certainly the advice that's been received is no, that they tend to be treated as separate collateral restrictions in a collateral remuneration agreement, and it doesn't impact upon the restraint of trade doctrine. In other words, the fact that someone is going to lose a big chunk of money under a payment scheme, whatever that payment scheme is, by virtue of moving to a competitor, and they're incentivized not to move to a competitor because otherwise they will receive a big chunk of cash. That's just the fact of contractual life. I don't think that would affect the enforceability of, let's say, a non-compete.
I'm going to ask you a question from Sue Love, but I suspect your answer is going to be, it depends. Sue asks, how enforceable are restrictive covenants on junior employees in a redundancy situation where the covenant prohibits them from, for 3 months after termination, being involved in any capacity with any competing business?
Well, if the fact that they're being made redundant, I'm not sure is pertinent to the enforceability of the covenant. The covenant is the covenant. The term that the circumstance or reason for termination is that particular reason for termination, redundancy, would not affect the enforceability of the covenants.
I think Sue's asking about the way the covenant is phrased. So, is a covenant for a junior employee that's for 3 months, preventing them from being involved in any capacity with any competing business, something that you feel able to advise on as to whether it's enforceable or not? Or is it?
That's a very widely drafted non-compete. Any capacity, any business. I wouldn't be able to advise upon something as wide as that without all the key facts. This is notoriously fact specific, and that might be enforceable in one set of facts and not in another, that particular covenant.
Really interesting question from Laura Riley. Laura says, clients often find it hard to define the business interest that they want to protect, and they find it hard to decide what a reasonable time frame is. Can you, Mo Sethi, give some pointers as to how to assess these factors?
Well, it's all those factors I pointed out earlier in answer to an earlier question as to when you're trying to draft a covenant, your touchstone has to be no wider than reasonably necessary. You've got to go through those stages that identify by, as you say, first identifying the legitimate business interest. But your question begs the problem, because the issue is, well, what if you can't define the legitimate business interest? Now, I'd say to you, if you can't identify a legitimate business interest, stop there. That's your problem. But in most cases, what employers will do is simply state broadly that they're trying to protect confidential information or trade secrets that the employee will come into contact with during the course or currency of the relationship, or client connections, or workforce stability, or all of the above. And just keep those categories quite broad. And it's not necessary in the drafting stage of the covenant to be very specific, any more specific, than that. So as long as you've identified those broad categories of confidential, protectable interests, that should suffice.
Very interesting question from Robert. Robert asks, given that courts won't enforce a covenant that it considers unreasonable, is there any benefit in having the employee sign multiple separate terms? So I think what Robert is asking is it okay to have a restrictive covenant clause 12, say, of a contract broken down into subparagraphs? 12.1, you shall not compete for a month. 12.2, you shall not compete for 2 months. 12.3, you shall not compete for 3 months, and giving the court a menu of options to choose from.
Firstly, that's very unusual. Secondly, it indicates that the employer hasn't really thought about what period of restriction it needs to impose to protect a particular legitimate interest. And it rather works against the employer to be so, to keep all of its options open like that. It actually helps to defeat the enforceability of the injunction rather than improve its enforceability, in my view.
Interesting question from Adrienne. She asks, is it more difficult for an employer to enforce post-termination restrictive covenants where the legitimate business interest is not set out in introductory words in the covenants? Adrienne, I'm going to switch that round from a double negative to a slightly shorter question. Will it help an employer enforce covenants if they've set out the legitimate aim in the covenants?
Sometimes if what you say you can be stuck with. Covenants can be enforced without identifying in the drafting what legitimate interest is being sought to be protected. And it can be argued later that the purpose of that covenant, so if it's a non-compete, was to protect confidential information, say. However, if it does say its purpose is to protect confidential information, but it doesn't say its purpose is to protect mere client connection, then on an injunction later, you may be stuck with the fact that your non-compete clause expressly limits itself to protecting confidential information and not client connection, unless, of course, the client connection is itself confidential information, such as the client list. So sometimes it's better to not specify the categories of legitimate business interest in the contract and argue it later. But if you are going to put it in, don't just put one in, put all of the above in terms of, confidential information, trade connections, workforce stability. And remember those categories are not fixed, but most 99.9% of the time, cases fall within one or more of those three.
Mo Sethi from Littleton Chambers is with us for another 10 minutes answering your questions on restrictive covenants. And the next question comes from Robert, who asks, are the chances of a court finding in an employer's favour increased if there is separate consideration for a post-termination restrictive covenant?
Yes.
Can you expand on that?
If the post-termination restrictive covenant is inserted at the beginning of the employment relationship, in other words, in the original contract, then whatever the salary is, part of that consideration goes towards agreeing the restrictive covenant. If the restrictive covenant is introduced midway through the relationship, then the employee needs some specified, identifiable consideration for entering into that more onerous term. And so if you do it mid-employment and specific consideration can be identified, then not only will it improve, actually it's an absolute necessity. So it's not a question of improving it, you must have it.
I think I read Robert's question slightly differently, Mo Sethi, but on the assumption that you've answered the question he asked, which you probably did, and I've misread it, let me ask you the question I thought he was asking. Let's assume that an employee has a salary of £30,000 and there's a covenant in there saying, don't go and sell widgets for a competitor for 6 months. Is the prospect of that covenant being enforceable increased if he has a salary of £29,500 and the contract says, and we're giving you an extra £500 for you signing this restrictive covenant?
It's all that does is extract out a very specific strand of remuneration as specific consideration. If that happens at the point of entry into the employment relationship at the very start, I don't think it makes a difference. But it's always good to have identifiable consideration for restrictive covenants. But I don't think it matters. It doesn't make a material increase in the prospects of enforceability at that stage, but it would if it was during the relationship.
Question from Linky Trot. I'm going to summarize this question. Do you think, Mo Sethi, that a restrictive covenant is enforceable if it's a 12-month covenant where a salesperson has monthly contact with their client base? Linky doesn't say whether it's a non-trading, non-dealing, non-solicitation, though.
So it's a 12-month and an industry where the salesperson has monthly contact with their client base.
I think Linky's question is aimed at whether it goes beyond what's reasonably necessary to achieve a legitimate business aim if if the employer can get a new salesperson in role within a couple of months, having all those regular conversations, that 12 months restriction isn't actually necessary.
If the implication of the question is, then would only a 1 month be justifiable and nothing more than 1 month post termination because the contact is monthly? I think that wouldn't work. I think you could still justify a 12-month post termination restraint for a employee who was only in touch with a customer base, let's say, for 1 month pre-termination.
Question from Julie Norris. Does a court or tribunal treat restrictions on a consultant, i.e. a self-employed individual, differently from those for an employee? Are non-compete clauses for consultants more likely to be reasonable?
Yes. In most cases, they may be treated similar to employee covenants. But if the consultant is in business on their own account, and it's a business-to-business restrictive covenant, then it's more likely, it can arguably fall within the realm of commercial covenants, and the courts tend to be far more keener to pull down commercial covenants and far more keener, therefore, to uphold them.
Helen Peach says, how strictly do the rules of contra preferentum tend to be interpreted against employers as regards restrictive covenants? So, for example, would a covenant saying that a person who's actually a barrister working for a firm of solicitors couldn't work as a solicitor in the same town be enforceable? Mo, perhaps when answering, you could explain what the rules of contra preferentum actually are.
It's essentially where if one party is the only party that's drafted the terms and it's their own standard boilerplate, detailed, incomprehensible terms, and the other party has simply signed up to it, whether when construing the meaning of those terms, if there is ambiguity in the meaning, and there are two possible meanings, that the court will interpret it as against the person that drafts it. In other words, as against the poor draftsman and for the employee on that example. It seems to me really that here, contra preferentum often doesn't figure in the restrictive covenant employment context, partly because you're essentially looking at, most of the time, covenants that are quite clear. They may not make sense, but they are clear, and they're often in quite standard terms. So any ambiguity in meaning is often done on the basis of the validity principle rather than contra preferentum.
Has contra preferentum really been killed off in restrictive covenants by the Tillman and Egon Zender case that you mentioned earlier?
Yeah, I mean, it is simply not an area which has resulted in any kind of fruitful legal developments. Certainly not for restrictive covenants.
Chris asks, is there anything that can be done in the drafting of a post-termination restrictive covenant that makes it more likely to be enforceable by a buyer following a TUPE transfer?
In the drafting of PTL, that makes it more likely to be enforceable by a buyer following a TUPE transfer. So, can be done in the drafting. Well, they can be transferable upon a TUPE transfer. A PTR is a term of the contract, and the contract remains in full force across the TUPE transfer. I think what the buyer should do, the transferee, it should try and ensure that upon the transfer, that the drafting is as equally applicable to the transferee as it was to the transferor. And the problems often arise where you have a TUPE transfer and the restrictive covenant ceases to make sense or just is dead for effect, because it may be only very specific and specifically catering for the needs of the transferor and not the legitimate business interests of the transferee. So unless it's a generically drafted one, it may not work, and even then there may be problems. So in the list of measures and the information consultation process that occurs during the TUPE transfer, it's essential on the term sheets to have a very specific section dealing with PTRs.
Question from Jamie Anderson. Morning, Jamie. Jamie says, you mentioned the ownership of assets, such as information, on LinkedIn. Is there any restriction in law as to how wide the employer can draft such a clause? For example, is there any law or principle which interferes with an express term, which effectively hands over the ownership of employees' social media to their employer? Mo Sethi.
So, restriction in law as to how wide the employer can draft such a clause. Well, if the employer owns the asset, my view on that is that the employer owns the asset, and it will be a matter of defining what the asset is. If the asset is confidential information, I see no difficulty so long as the confidential information is sufficiently rigorously defined in the confidentiality clause. The problem we often have, you see, is that confidentiality clauses are generically drafted. And in my view, actually, most of the time, as drafted, they're not particularly enforceable. The confidentiality clauses, that is. What is enforceable are the particular circumstances of the employee stealing or extracting, retaining, misusing, disclosing confidential information, and being in breach of the implied equitable obligation of confidence. Now, applying that here, the issue is there any law principle which interferes with an express term which effectively hands over the ownership of employees' social media to their employer? I think I've answered that by simply the question of who owns the asset.
I wonder, Mo Sethi, if there's any argument that public policy dictates that a clause in a contract saying that an employee hands over their acquired social media contacts, which they may have acquired over years and years and years, to an employer, is void for public policy unless there's a compelling reason to enforce it.
There are notoriously difficult questions on a LinkedIn account, say, or a Twitter account, where the account is owned by the employer, it's the owner's asset, but the data contained on the account is a mixture of the employer's information and personal, private realm information of the employee. And so, yes, there will be human rights arguments on grounds of privacy. There'll be data protection issues, perhaps GDPR issues also. So there are a number of arguments that will come to the fore in relation to why the employer should not be entitled carte blanche to have its entire LinkedIn account, say, back and the entire contents of it, where the contents are mixed in with data which is clearly owned by and private to the employee.
Mo Sethi, thank you very much.